the business guy. Today we're going to talk about protecting assets from lawsuits. I've been in the asset protection business since 1991, and our company has personnel in California, Washington, D.C., Washington State, Rhode Island, Florida, Nevada, and Missouri. And so we have people across the country. We also have a location down in the Caribbean island of Nevis. And so let's break the asset protection from lawsuits talk here into three parts. One, protecting liquid assets. Two, protecting assets that are real estate, and also protecting personal property, such as business equipment, art, things of that nature that aren't real estate or cash. Okay, so what do you do to protect the liquid assets? To protect the liquid assets, there are some structures that are have been the strongest in looking at the case law, and we have attorneys on staff with our company, and they can tell you that when they study the case law, we study the case law with the domestic asset protection trust, the trusts that are offered in various states. The results aren't very good. With the increasing theories of legal liability, what we've seen is these things get penetrated quite regularly because U.S. courts have jurisdiction over local trustees and local assets. Judges are consistently allowing these domestic trusts to be penetrated. And so, especially if somebody has a lawsuit threatened, they have say getting in a divorce, maybe they've already been served with a lawsuit, pretty much anything domestic's not going to work. So for liquid assets, our best strategy in that case is setting up an international asset protection trust. The reason why it's so effective is that U.S. courts don't have jurisdiction over foreign trustees, foreign banks, and so on. And so when we establish a trust, let's say in the Caribbean island of Nevis, in the Cook Islands, we have law firms down there that will stand in as the trustees. And the U.S. courts don't have jurisdiction over these foreign law firms. So when the U.S. courts say, give me the money, the offshore trustee says, no, not going to. We have very, very credible personnel that serve as trustees, been working with them for years. And as of this recording, I've been in the business for 29 years, set up more offshore trusts than anybody on the planet. And it has been extremely, extremely effective for protecting our clients' assets from lawsuits. And what we'll typically do is we'll stick a limited liability company, typically a limited liability company in the Caribbean island of Nevis. I've done extensive study on the different LLC legislation in the different jurisdictions, and the Nevis LLC tends to offer the strongest asset protection. So what we'll do is we'll stick a limited liability company inside of the trust. The client is the initial manager, the signature on the bank accounts, and then when the bad thing happens, there's an event of legal duress, the trustee can step in as not only trustee of the trust, but additionally as manager of the LLC, and that way they step in to protect the client's assets from lawsuits, so that when the U.S. courts say, give me the money, our offshore law firm that has now become the manager of the LLC says, sorry, not going to, you don't have jurisdiction down here. Our clients are very cooperative with the courts. They'll write a letter to the trustee saying, please bring back the assets right now. The courts are ordering me to do so. And we have a duress clause in the trust, so when the client is requesting the repatriation of funds under duress, the trustees recognize this and do not bring the assets back. Now, if the settler or the trust beneficiary requests the funds of their own free will, well, that's a different story. But it's pretty clear if they're being pressured to bring it back rather than doing it voluntarily. So that's been the most effective strategy. Again, the funds need to be internationally. U.S. courts have jurisdiction over U.S. banks and real estate. So the key thing is, if the funds are in an offshore trust and the assets are in an offshore bank, it's going to be nearly impossible for a judgment creditor to seize those assets. And so that's the main strategy for liquid assets. Now let's talk about protecting real estate. Now, again, like we talked about with the domestic versus offshore banks, The real estate is typically going to be domestic, let's say U.S.-based real estate. U.S. courts have jurisdiction over the U.S.-based real estate. Plopping the real estate in an international structure is not going to be very effective strategy because the U.S. courts have jurisdiction over the real estate. I don't care if you have that fancy trust, I'm going to take it anyway. They can't do that if you have it in a trust and the funds are in an offshore bank account because U.S. courts don't have jurisdiction over either. So what do we do with real estate? What we do is multitude of strategies with real estate, one of which is equity stripping, one is privacy of ownership, and one is protection from lawsuits from the property itself. So what we'll do with real estate is we'll typically stick each piece of property into a land trust for privacy of ownership. We will have a limited liability company as the beneficiary of each land trust. That way, if you look in the public records and you see John Smith as the president of the LLC, and then you do a second search to see what kind of assets that LLC owns, you don't want to have that LLC showing up as owning a bunch of assets. If the property that it owns indirectly is in a land trust instead of directly held in the company, the land trust acts as a buffer between the person and the company, so it gives privacy of ownership. So that's the reason why we structure the real estate in that fashion. Ownership is in an LLC. It's a tax-neutral structure. The ownership is in a land trust. It's a tax-neutral structure. The LLC is the beneficiary of the land trust. And that way you have a lawsuit protection. If there's a lawsuit on the property itself, the LLC can help stop that lawsuit from affecting the humans associated with the company. And if the people are sued personally, there are provisions such that if especially if it has two or more members in each state, in most states, when the human being is sued personally that owns the LLC, there are provisions such that the LLC, any assets in it, are protected through a charging order. So we'll get there's other videos that go into more detail about the charging order, but you have lawsuit protection if there's a lawsuit on the property itself. You have asset protection if the people who own the company get into a lawsuit and they're sued personally. And then the third strategy we employ with real estate is called equity stripping. Equity stripping is where we place a mortgage against the property, mortgage or deed of trust, depending on the state, but it's an encumbrance on the property. Initially, we will have that encumbrance payable to an LLC that the client owns privately, such as the Nevis LLC that's in the offshore trust, for example, initially. And that'll be an equity line of credit mortgage, so there's no money changing hands. And then, if needed, and this only happens in maybe 1 out of 100 or 1 out of 200 cases, we have a third-party lender who will purchase the mortgage from your LLC and place the proceeds in your offshore asset protection trust. So again, that's equity stripping. Again, plopping the real estate in an offshore structure, not very effective because courts have jurisdiction over the property. Yeah, because it's domestic, right? And so that's the reason why we employ equity stripping. So we use a different strategy if it's real estate as opposed to liquid assets. So, and again, if a third-party lender purchases the mortgage and puts the proceeds in your offshore trust, that won't be money you could rub your hands together and run away and spend. That would be too risky to the lender. But it does show the judge that it's a genuine mortgage against the property, truly payable to a third party, and the reason you placed it on there to begin with is for the purpose of selling the mortgage to a third party to raise capital, which you have done because you can show the judge you received the proceeds in your offshore trust. Okay, so now let's talk about personal property. Personal property, we typically use a very similar strategy to the strategy we use with real estate, but the instrument's a little bit different. It's a UCC 1. That's a Uniform Commercial Code 1. It's a kind of a mortgage or encumbrance against personal property, such as let's say automobiles, and that would be things like art, airplanes, those kind of things. So we record a UCC 1 with an equity line of credit, and that's forms an encumbrance against the personal property items. And if you have membership in a private LLC, we can record it against the LLC. Let's say you own part of an LLC with a partner that owns real estate. Okay, you wouldn't be able to encumber the whole property because, hey, that's not yours to encumber. It's you own it with other people within an LLC. But we can record a a UCC1 against your portion of the membership interest in that LLC, and that will be initially payable to the LLC we established for you privately. And then if needed, we have a third-party lender who can come in and purchase that encumbrance from your LLC and then deposit the funds in an offshore trust. So that's those are the strategies we employ for liquid assets, for real estate, and for personal property. So I hope that's helpful. And if you have any questions, give us a call. You can visit us at assetprotectionplanners.com. That's assetprotectionplanners.com. You can give us a call at 1-800-830-1055. That's 1-800-830-1055. And we have, like I say, professionals, consultants on staff, including attorneys on staff, and we can help answer your asset protection questions. Thank you.